Mr. Chairman. I do appreciate it, and I appreciate the words of not only both you and Mr. Johnson, but also the full committee chair as well. This is the first of many of these hearings, and we're looking forward to going forward. The right to vote is what makes democracy a democracy. America's federal law has protected this right from discriminatory barriers since the Civil War, and more recently through the Voting Rights Act of 1965. Americans oppose racial discrimination as incompatible with democracy, and our current laws reflect that conviction. In 2013, the Supreme Court struck down a single part of the Voting Rights Act, Section 4. That provision automatically put certain states and political subdivisions under the Act's Section 5 pre-clearance requirements. Those pre-clearance requirements prevented voting rules change covering jurisdictions from going into effect until the new rules have been reviewed and approved, either following a federal lawsuit or more often by the Department of Justice. When the Voting Rights Act was enacted, Section 4 identified the jurisdictions automatically subject to these special pre-clearance requirements by a formula. The first part of the formula provided that a state or political subdivision would be covered if maintained on November 1, 1964, a test or device restricting the opportunity to register and vote. The second piece provided that a state or political subdivision would also be covered if the director of the census determined that less than 50% of persons of a voting age were registered to vote on November 1, 1964, or less than 50% of the persons of voting age participated or voted in the presidential election of November 1964. In its Shelby County decision, the Supreme Court struck down the automatic pre-clearance provision because the original coverage formula was, quote, based on decades-old data and eradicated practices. In 1965, the states could be divided into two groups, those with a recent history of voting tests and low voter registration turnout, and those without those characteristics. Congress based its coverage formula on that distinction. Today, the nation is no longer divided along those lines, yet the Voting Rights Act continued to treat it as if it were. The courts further criticized Section 4's formula as relying on decades-old data relevant to decades-old problems rather than current data reflecting current needs. In Shelby County, the Supreme Court only struck down that single outdated provision of the Voting Rights Act. Significantly, the other very important provisions of the Voting Rights Act remain in place, including Sections 2 and Sections 3. Section 2 applies nationwide and prohibits voting practices or procedures that discriminate on the basis of race, color, or the ability to speak English. Like other federal civil rights laws, Section 2 is enforced through federal lawsuits, and the United States and civil rights organizations have brought cases under Section 2 to the court, and they may do so in the future. Section 3 of the Voting Rights Act also remains in place, authorizing federal courts to impose pre-clearance requirements on states and political subdivisions that have enacted voting procedures that treat people differently based on race in violation of the 14th and 15th Amendments. If the federal court finds a state or political subdivision to have treated people differently based on race, then the court has the discretion to retain supervisory jurisdiction and impose pre-clearance requirements until a future date at the court's discretion. This means that such state or political subdivision would have to submit all future voting rule changes for approval to either the court itself or to the Department of Justice before enacting those changes. Per the Code of Federal Regulations under Section 3C of the Voting Rights Act, a court in voting rights litigation can order as relief that a jurisdiction not subject to pre-clearance requirements of Section 5 pre-clear its voting changes by submitting them either to the court or to the Attorney General. Again, Section 3's procedures remain available today so people can challenge voting rules as discriminatory. In 2017, for example, U.S. District Judge Lee Rosenthal issued an opinion requiring the Justice Department to monitor the city of Pasadena, Texas, because it had intentionally changed its city council districts to decrease Hispanic influence. The city, which the court ruled had a long history of discrimination against minorities, was required to have their future voting rules changes pre-cleared for the next 6 years, during which time the federal judge retains jurisdiction to review before enforcement any change to the election map or plan that was in effect in Pasadena on December 1, 2013. A change to the city's election plan can be enforced without review by the judge only if it has been submitted to the U.S. Attorney General and the Justice Department has not objected within 60 days. This is the basis of this hearing, and I'm glad that we're having it, and I look forward to the witnesses and the questions that will come. With that, I yield back.